You know, gay rights were a new thing. And it's, when we say that the Montana Constitution is a living document, we're saying that it encompasses the evolving standards of decency as the U.S. Supreme Court talked about it with respect to cruel and unusual punishment. But I'd like the delegates to also comment on this evolving living document that we have.
Well, I'd like to actually use that as a segue to something Justice Nelson mentioned in a class last week, and that is, you know, as Attorney General Bullock mentioned, there is this bound set of proceedings of the Constitutional Convention where you can actually go and you can read the delegate proposals, you can read the reports of each of the committees, you can read in the words of the majority and the minorities for each of those committees what their intention was with respect to adopting each of those articles. And then in addition, you have the verbatim debate of the delegates as to what each of these provisions could mean, at least at the time. Now, one of the things that Justice Nelson commented on in talking a little bit about how does the court go about interpreting what the delegates meant. Well, actually, how do they go about interpreting what the Constitution means? Do they look to the delegates and what we meant, or something else? So would you comment a little bit on that? Because I thought that was very important, and it's timely, too, in terms of Justice Scalia on the United States Supreme Court trying to say we need to sort of stay focused on what they meant back in the time the federal Constitution was adopted.
Sure. Well, Justice Scalia's got a much more difficult problem than we do. He's looking back 200 years and trying to interpret a modern Constitution, and theoretically at least a living Constitution, by what it meant 200 years ago, which I have always maintained is an exercise in futility. Very frequently, when we interpret Montana's Constitution, make decisions on the Supreme Court, we look to that set of books that General Bullock referred to, a bound set of books containing the transcripts of all of the debates, what the delegates said, pro and con for a particular provision. And when we started developing the right of privacy, for example, in our jurisprudence in Montana, when I initially got on the court, we looked to see what the delegates said about the right of privacy and their concern about the government interfering in people's private affairs, the concern that they expressed about electronic surveillance, eavesdropping, and those sorts of things. And it was important for us to get a sense of where the delegates were going. And Betsy mentioned that the Constitution is a living document, and it is. We know that the delegates were concerned about electronic surveillance and intrusions into people's private lives by the government. Did the delegates envision personal computers? No, they didn't exist. Did they envelop or envision an internet? No. Cell phones? No. Fax machines? No. None of the modern technology that we deal with today was on the minds of the delegates. Those things just didn't exist. But at least we know what they were concerned about. And they were concerned about government interference in people's affairs. And that's an example of how we use the constitutional transcripts. Do you want me to go ahead and say the rest of what I said?
Sure.
Okay. I kind of, and to put this in context, the discussion occurred with Betsy Griffing's constitutional law class last Friday at the law school, and it was really a fantastic situation. Anthony Johnstone was there. Anthony teaches constitutional law at the law school and was formerly a solicitor for the state of Montana. Mae Nan was there, I was there, and of course Betsy and the law clerks also participated with us, but we had an incredible discussion with the students. But having kind of made the remarks that I just did about the importance of the transcripts, I said that, and while I used to believe that was really important in interpreting the Constitution, I've changed my mind over the years, and it's one of the benefits of being on the court for so long. You have the ability to change your mind occasionally, and I have kind of changed my mind. I think that we need to focus more now going forward on the plain language of the Constitution, or it is unambiguous and plain. And I say that for a couple of reasons at least. We're now 40 years away from when the Constitution was adopted, and for kind of the same reasons that I just expressed, our society has moved on in different directions with different technology, different morals, different mores, and I think the delegates' intent at the time maybe is becoming less relevant as we move forward with our living document, the Constitution. Another reason that has been expressed, and I think it's true, when the people voted on the Constitution, they could have, but obviously, realistically, they didn't read all those transcripts. They probably were not privy to all of the debates and what went on. The people voted on the Constitution pretty much based on the plain language of what they saw. There was a little newspaper kind of a thing that's a voter information pamphlet that gave people kind of a rough idea of what the constitutional provision was about. But they pretty much voted on the plain language, and the people adopted the Constitution, and if they adopted the Constitution on the basis of the plain language that was before them, that's perhaps, I think, maybe the better way that we should interpret it as well. So, as I said, I think that the delegates' intentions, as expressed in the transcripts, is important. We used it, I have used it, and in fact, the court still uses it. But at least in my view, I think as we go forward, that maybe we need to focus more on the plain language of the document itself. In saying that, and I want to get this point across as part of the conversation here, Montana's Constitution is a visionary document. It is a document that is full of vision that I think is going to last the ages. It's really a compact with the people for a just government. That's really what our Constitution is. I've said this in opinions I've written, it's not simply a cookbook of discrete rights. It's not written with the vitality of an automobile insurance policy. It's a document that is written with vision and with the idea that it is a compact for just government. And so when I say look at the plain language of the document, there's a lot in that plain language for this and future generations.
You know, Judge, I want to tell you that's a brilliant summation of exactly what took place during those 56 days. What I'd like everybody to understand is we met for 56 days. The constitutional provisions are almost all in constitutional language except for Section 16. We had to kind of log jam the third-party lawsuit into it. But what we did was prepare a pamphlet. Each committee prepared a pamphlet. Here's the pamphlet for the Bill of Rights Committee. This was given to every delegate prior to our debates. In that pamphlet, with respect to the right of individual dignity, the committee, and I'm going to read this for you because I think it's going to be helpful for understanding what's already been said, although I'm not going to improve on what Judge Nelson said. He's absolutely correct. This was a visionary document that I think can go on for centuries. The committee unanimously adopted this section with the intent of providing a constitutional impetus for the eradication of public and private discrimination based on race, color, sex, culture, social origin or condition, or political or religious ideas. The provision, quite similar to that of the Puerto Rico Declaration of Rights, is aimed at prohibiting private as well as public discriminations in civil and political rights. Then we close with this paragraph. The wording of this section was derived almost verbatim from Delegate Proposal number 61. The committee felt that this proposal incorporated all the features of all the delegate proposals number 10, 32, 50, and 51 on the subjects of equal protection of the laws and freedom from discrimination. The committee is well aware that any broad proposal on these subjects will require considerable statutory embellishment. It is hoped that the legislature will enact statutes to promote effective eradication of the discriminations prohibited by this section. The considerable support for and lack of opposition to this provision indicates its import and advisability. Now, I think you should all understand some of the history that's involved. The League of Women Voters in the early 60s decided that we needed a new constitution in Montana. They convinced the legislature that there should be a committee developed for constitutional revision. The Supreme Court was authorized to appoint 4 people to that 16-member committee. Supreme Court appointed 4. I'm privileged to say that in that first Constitutional Revision Commission, I was one of the 4 appointed by the Supreme Court. And then there was a second Constitutional Revision Commission. Finally, the legislature said, yes, we have to have a new Constitution. So what happened? The appropriate law was passed, and then they started hiring individuals that would provide the background for the delegates whenever they would meet to debate, chart, draft, write the new Constitution. They appointed a gentleman by the name of Dale Harris, a very bright academic. He then appointed, or hired, I should say, other bright young academics. So they worked for 2 years on background materials. When Forrest Anderson greeted us all after the election and said all the nice things that the governor should say about us, he then indicated very clearly what our objective should be and what our vision should be, and a time was scheduled in January of 1972 when we would all appear and begin our deliberations. And before we did that, we were given 2,300 pages of research materials on all the subjects that we're talking about. In our Bill of Rights Committee, with respect to individual dignity, I thought the 14th Amendment to the United States Constitution might be sufficient. I'm delighted to say that there was so much discussion in favor of having this particular language that it was adopted, and if I recall correctly, Mae Nan, without any